Let's talk about a lawsuit that threatens to redefine the extent of the composition copyright forever, and also brought hundreds of artists out in an ultimately unsuccessful bid to defend perhaps one of the most controversial one-hit wonders of the last decade. I'm talking, of course, about Blurred Lines. Arguably the biggest hit of 2013, Blurred Lines was written by Robin Thicke and Pharrell Williams with a guest appearance by T.I. Harris. Blurred Lines was a smash hit and part of a massive retro wave during the summer of 2013, along with tracks like Take Back the Night by Justin Timberlake and Get Lucky by Daft Punk. Controversial both at the time of its release and now for things as varied as its production, its lyrics, its messaging, and arguments of cultural appropriation. Nothing has been more impactful from this song than the lawsuit that we're about to discuss. As part of this wave of retro hits, Blurred Lines was accused of being too closely inspired by one particular song, Marvin Gaye's Got to Give It Up, and his estate took notice. Released in 1977, Got to Give It Up is one of the most well-known songs released by artist Marvin Gaye. A smash hit during its time, Got to Give It Up topped 3 different Billboard charts and was often used as an opening number by Marvin Gaye during his concerts. Influential during its time and afterwards, Got to Give It Up both inspired Michael Jackson's shift from his Motown career with the Jacksons to his solo career as a pop icon. This song has been used in dozens of films and television shows and been covered again and again through the decades, with popular performances such as those by Isla and Justin Timberlake being smash hits in their own right. Noticing the similarity between Blurred Lines and Got to Give It Up, the estate of Marvin Gaye's family threatened to sue, claiming copyright infringement and setting a notice to the rights holders of Blurred Lines, which was the label, Pharrell Williams, Robin Thicke, and T.I. The exact procedural basis for this case can get a little bit complex, so we're just going to be talking about the basic elements of the suit, and we'll start with what was in question, the composition copyright. Now, as we've discussed in an earlier video, there are 2 types of copyrights that are associated with a song: the copyright of the sound recording and the copyright of the composition. Now, as is usual, the sound recording was owned by the label, and what the estate had was the composition. And so what they were suing for was a violation of the composition of Got to Give It Up. And this is going to become relevant in a little bit when it gets to how the case was heard. The second thing that we're going to discuss is the declaratory judgment. Now, in this case, instead of waiting to be sued, the holders of the rights to Blurred Lines, Williams, Thicke, and T.I., went to the federal court and they sued, showing that there was a demonstrated threat of litigation from Gaye's estate, and asked to be heard to have a judgment on the books through a summary proceedings that would essentially rule that it wasn't violation, that their work was protected. Now, unfortunately, when they went for this declaratory judgment, they did lose. But in essence, this is done by a lot of people who are being threatened with lawsuits that could cost them a lot of money, but have a strong faith in the strength of their claim. And the rights holders, they had a good reason to believe this. As, several musicologists and industry participants and experts have noted, there really isn't any specific similarity between the 2 songs. Yes, They evoke the same feel, they belong to the same genre, and there is a definite line of inspiration. But when you look at the songs, there's not any similar musical phrase, any similar notes. There is a lot of difference there. And so for this reason, they were confident and they thought they could go and get a simple declaratory judgment and have the case on the books. Unfortunately, that didn't go their way. And in 2014, the estate of Gaye was given the go-ahead to actually file a lawsuit against Williams, Thicke, and T.I. With this favorable judgment, the estate of Marvin Gaye, his family and heirs, decided to indeed sue Williams, Thicke, and T.I. for proceeds from the composition, as well as credit being given to Marvin Gaye for the composition itself. Now, again, what happened in this suit is a lot of back and forth of motions, filings, hearings, and evidence that is a little bit beyond the scope of this video. But what we're going to focus on are a couple of filings that illustrate some of the issues involved in this case. The first is the motion for summary judgment. Now, this is a motion that is filed almost by reflex whenever anyone receives a lawsuit. And this is essentially asking the judge to dispose of the case then and there. That the case doesn't have any merits, it's not worth going through the time and expense of a full lawsuit, so please just give us your judgment right now and, throw this in the bin. This was denied, and the motion went forward. There was this standard, complex, and lengthy procedure of a trial. Now, during this, there were several motions that were made with regards to the evidence, one of which is particularly interesting, and this was a motion in limine, which was filed by Williams and the other composers to prohibit the estate from playing the actual recording of Got to Give It Up in the court. Now, why were they able to make this argument? This goes back to what we were talking about in terms of the two separate rights that are involved in the song. Now, the actual recording that they wanted to play, the popularized sound, the song itself that comes on the radio, this is a sound recording that's owned by the label. This isn't something that the estate of Gaye owns, and it's not the basis of their suit. The basis is the composition. And so Williams and his co-writers were able to argue that instead of playing this, which has improvisations and elements in it that aren't part of the composition, and contributions by sessions musicians and other participants that again aren't part of the composition, that would unfairly imply to the jury that the copyright extended further than it did. And they were actually successful in this. Initially, the judge said that only the sheet music would be able to be presented as the work that is protected. And ultimately, when, clearly the jury wasn't made up of people that could sight read the music, there was a recording that was made and played for the jury. But that recording was of an incredibly stripped down version of the song. It got rid of all of the improvisations. It got rid of all of the contributors that weren't part of the composition. And it was a very boiled down, stripped down version of Got to Give It Up that was ultimately played. Because that was all that was protected. So what followed were dozens and dozens of motions, expert testimony from both sides, musicologists that argued both that there was infringement and that there wasn't infringement, legal arguments for hours and hours, and ultimately the jury decided that Blurred Lines actually did infringe on the copyright of Got to Give It Up. And this was a huge upset. Very few people expected this suit to go the estate's way, and yet at the end of the trial, the jury found that there was infringement. They also found that there infringement was not willful. Now, why this willful element matters is because of punitive damages. Now, what happens in a lawsuit like this is, first, if there is a wrong, if rights were violated, the exact amount of loss is argued, and the jury decides on whatever basis of calculation they do, that this was the amount of damage that was suffered by the plaintiff, and this is how much they should recover on that basis. But if the violation is held to be willful, they're also going to add an additional element, punitive damages, and these can be enormous. This is essentially an additional award against the defendant to punish them. It's calculated not on the basis of how much harm the plaintiff suffered, but on how much the jury feels the defendant's action was wrongful and how much they should be punished. And it can often dwarf the amount of actual damages. Luckily for the writers of Blurred Lines, they were not held to have willfully infringed. However, the jury still returned a verdict of approximately $7.4 million, and additionally held that Marvin Gaye would have to be given credit. Hearing this judgment, Williams, Thicke, and T.I. filed a motion for a new trial, arguing, among other more procedural grounds, that the verdict simply didn't match the evidence, that everything presented would have suggested a verdict against the plaintiffs, and that the jury was clearly erroneous. And the judge in the trial denied this, and this is routine. Both the filing for a new trial and the denial are fairly standard outcomes of a trial like this. So the writers of Blurred Lines decided to appeal the case. They challenged, in particular, the judges holding on two of their motions. The motion against summary judgment, the motion they made at the beginning of the case asking for it to be thrown away because there were no merits to the claim, and the motion for a new trial that they filed at the end of the case saying that the verdict of the jury was clearly against the evidence. And when they appealed this case, this is when the support from the industry came out of the woodworks. 212 artists, including such unlikely bedfellows as Hans Zimmer, Fall Out Boy, John Oates of Holland Oates, and Jennifer Hudson, signed on to an amicus brief drafted by Ed McPherson and filed in defense of the appeal. Now, an amicus brief is a filing made by a third party to a suit that is there to provide information or a perspective that may be helpful to the court in reaching a verdict. In their amicus brief, these artists stated that the two songs, quote, do not have similar melodies, the two songs do not even share a single melodic phrase, end quote, and they accused the jury of ruling simply on the basis of a similar feel or groove between the songs, neither of which are elements that can be protected by copyright. In addition to this, a series of musicologists filed a second amicus brief, providing what they considered to be the proper professional stance concerning the comparison of Blurred Lines and Got to Give It Up. In part, this amicus read, quote, there can be no genuine disagreement among experts as to the fact that there is no harmonic similarity between Blurred and Give, because the chord progressions in both works were entirely different, end quote. Despite all of this industry support, Williams, Thicke, and T.I. ultimately lost their appeal. Now, the motion for summary judgment was disposed of largely on procedural grounds. There was a general principle of procedural law in the Ninth Circuit, which is where this case was heard, that the summary judgment has to be appealed during the trial, not after a full trial has been completed. And there were some additional concerns about the scrutiny applied by the court, but that was largely gotten rid of on procedural grounds. The motion for a new trial, however, is where the facts of the case came into the picture. And here the Ninth Circuit decided that they were going to adopt an extremely deferential standard of review. They weren't going to review the case de novo, which is fresh by looking into the facts and the law all, new. They were instead going to adopt a extremely deferential approach towards the verdict by the jury, where only an absence of evidence would entitle the plaintiff, which is the writers of the song, to get their motion approved, to have that denied motion reinstated, and to get a new trial. And in this case, they held that because there was expert testimony on both sides, there wasn't an absolute absence of evidence, and therefore the motion was properly denied. Now, in this case, there was a dissenting opinion by someone on the court who disagreed vehemently by the holding of this appeal. And they argued that the weight of the evidence was so strongly against the actual holding of the jury, and the briefs that were filed, the amicus briefs that were filed were so compelling that this case should be heard again, particularly because of how it redefined the concept of a composition copyright. And she held that, in essence, the Gaye estate managed to do something that had never been done before. They were able to copyright an entire style of music. Now, because of the breadth of this holding, she argued that the court should have gone into the merits a little bit more and actually had a new trial, if nothing else. But the majority, unfortunately, disagreed with her on this grounds, and the trial court's holding that Blurred Lines indeed was an infringement of the Marvin Gaye's estate's rights in the composition of Got to Give It Up was upheld. And that meant that, the damages and the credit were due. Although the court did reduce the damages from a little over $7 million to a little over $5 million. But the law that was found in that case was upheld at the Ninth Circuit Court of Appeals. So what does this mean for the future of composition copyrights and musical creation as a whole? Because as the amicus brief argued, and as was widely thought to be the case when this suit was filed, this wasn't a case of infringement as understood by the interpretation of then existing body of law. There was no similar expression. There was no overlap in terms of the musical phrasing. There were different chord structures involved. There was no overlap in terms of the actual notes played. Rather, it was the sound and the feel of the music that was adjudged to be too similar. And this can be concerning for a lot of different players in the musical industry. First, there is the concern of actual artists that like to borrow heavily from the styles of the past. Those that are either throwback artists like, Bruno Mars, or that sample or borrow from those sources in order to develop new blended or fusion styles of music. And those creators have to be concerned about the extent of composition copyrights being brought to potentially just the style of music, given how broadly that can be construed. But beyond that, there is an entire industry that we've actually discussed before on another video that is involved in the production of sound-alikes, which is music that is carefully constructed not to infringe on the copyright of other works, but to deliver a similar feel, to essentially be a non-infringing low-budget substitute for these works. And that entire industry, even more than those that are looking to rework or recreate the sound of the past, are going to be concerned. Now, since this wasn't a de novo holding, the Court of Appeals didn't look at the facts, look at the law, and make a judgment themselves. Rather, they deferred to this one jury's determination. It's not exactly clear that this is how future cases are going to be determined. But the fact of the matter is, this one case was determined this way. Marvin Gaye's copyright was held to include songs that sound and feel like his, and this was appealed and upheld. So in the future, whether you are a sound-alike artist or whether you are someone that is heavily inspired by the sounds and styles of the past, the Blurred Lines case is one to keep in mind. Thank you for watching. If you like this video, please like, comment with your thoughts, share it with friends and family, and subscribe to see more content.